The International Criminal Court, or ICC, stands as a beacon of hope for victims of the gravest crimes. Established by the Rome Statute in 1998, the ICC is the world's first permanent international criminal court. It intervenes when national courts can't prosecute genocide, crimes against humanity, war crimes, and aggression. The ICC's creation marked a pivotal moment in international law. Headquartered in The Hague, it operates independently of any state or organization. The ICC's existence serves as a powerful deterrent, reminding individuals in positions of power that their actions have consequences. The journey towards a permanent international criminal court has been long and arduous. It is a path paved with both triumphs and setbacks, reflecting the complexities of international cooperation and the evolving understanding of international justice. The seeds for the ICC were sown in the aftermath of World War II with the Nuremberg and Tokyo trials. These tribunals, established to prosecute Nazi and Japanese war criminals, marked the first time that individuals were held accountable for international crimes by an international court. The Nuremberg Principles, which emerged from these trials, laid the foundation for modern international criminal law. Despite the significant precedent set by Nuremberg and Tokyo, the Cold War hindered further progress towards a permanent international criminal court. The ideological divide between the superpowers stalled any meaningful discussions on international justice for decades. However, the end of the Cold War ushered in a renewed commitment to human rights and accountability. The 1990s witnessed a surge in efforts to address past atrocities and prevent future ones. The establishment of the International Criminal Tribunals for the former Yugoslavia and Rwanda demonstrated a growing international consensus on the need for international criminal justice. The experiences of the International Criminal Tribunals for the former Yugoslavia and Rwanda, while instrumental in advancing international criminal law, also highlighted the need for a permanent and independent court. The ad hoc nature of these tribunals meant that they were established after crimes had been committed, often delaying justice. In 1998, after years of negotiations and intense diplomatic efforts, the Rome Statute of the International Criminal Court was adopted. This landmark treaty, signed by 120 states, established the ICC as a permanent court with a mandate to prosecute individuals for the most serious crimes of international concern. The Rome Statute represents a delicate balance between the need for a strong and independent court and the sovereignty of states. It outlines the court's jurisdiction, the principles of complementarity and admissibility, and the rights of the accused. The ICC's jurisdiction is based on the principle of complementarity, meaning that the court can only investigate and prosecute cases when national courts are unable or unwilling to do so genuinely. This principle ensures that the ICC acts as a court of last resort, complementing rather than replacing national justice systems. The ICC's jurisdiction is limited to the four core crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. Genocide, defined as acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group, stands as a stark reminder of humanity's capacity for unimaginable cruelty. Crimes against humanity encompass a range of atrocities, including murder, extermination, enslavement, torture, and sexual violence, when committed as part of a widespread or systematic attack directed against any civilian population. War crimes violate the laws and customs applicable in international armed conflict, encompassing grave breaches of the Geneva Conventions and other serious violations of international humanitarian law. The crime of aggression, added to the Rome Statute in 2010, criminalizes the planning, preparation, initiation, or execution of an act of aggression by a person in a position effectively to exercise control over or to direct the political or military action of a state. The ICC's founding principles, enshrined in the Rome Statute, guide its operations and ensure its legitimacy. Key among these is the principle of complementarity, which underscores the court's role as a court of last resort. Section 5. Landmark Cases. The ICC's impact on global justice. Since its inception, the ICC has opened investigations in over 20 situations across Africa, Asia, and South America. These investigations have targeted individuals accused of a wide range of crimes, from the use of child soldiers to mass atrocities. The ICC's first trial, against Congolese warlord Thomas Lubanga Dilo, commenced in 2009. Lubanga was accused of recruiting and using child soldiers in the armed conflict in the Democratic Republic of Congo. His conviction in 2012 marked a significant victory for the court. Another landmark case involved Bosco Ntaganda, a former Congolese rebel leader found guilty of war crimes and crimes against humanity. Ntaganda's conviction in 2019 for crimes including murder, rape, and the recruitment of child soldiers sent a powerful message. The ICC, despite its noble goals and significant achievements, has not been without its critics. Some argue that the court's focus on Africa has been disproportionate, leading to accusations of bias and neo-colonialism. Critics point to the fact that all of the ICC's investigations, until recently, have been in Africa, arguing that this reflects a double standard in the application of international justice. The ICC has also faced criticism for its slow pace and high costs. Investigations and prosecutions can take years, if not decades, to complete, leading to frustration among victims and observers alike. The court's budget, funded by contributions from states parties, has also been a point of contention. Another challenge facing the ICC is the lack of cooperation from some states. The court relies on states to arrest suspects, surrender evidence, and enforce its sentences. However, some states have been reluctant to cooperate, hindering the ICC's ability to carry out its mandate effectively. The ICC operates within a complex international system where state sovereignty reigns supreme. The court's relationship with states is multifaceted and often delicate, requiring careful navigation to ensure both the effectiveness of the court and the respect for state sovereignty. The principle of complementarity, enshrined in the Rome Statute, is central to the ICC's relationship with states. This principle underscores that the ICC is a court of last resort, intervening only when national courts are unable or unwilling to prosecute. However, the ICC's reliance on state cooperation for arrests, surrender of suspects, and enforcement of sentences creates a point of tension. States may be hesitant to cooperate with the ICC if they perceive its actions as infringing upon their sovereignty or if they disagree with the court's investigation or prosecution strategy. The ICC's relationship with non-states parties, particularly powerful states that have not ratified the Rome Statute, presents another layer of complexity. These states are not legally bound by the court's decisions and may even obstruct its work. The United States, for example, has had a long and complicated relationship with the ICC, supporting the court's objectives in principle while expressing reservations about its jurisdiction and potential impact on U.S. sovereignty. The ICC, though still in its nascent years, has made significant strides in advancing international criminal justice. However, the court faces ongoing challenges that require continued efforts to strengthen its effectiveness and legitimacy. Enhancing state cooperation is paramount to the ICC's success. States parties to the Rome Statute have a legal obligation to cooperate with the court, and fulfilling this obligation is essential for ensuring accountability for the gravest crimes. The ICC must also address concerns about its perceived bias and selectivity. Expanding the geographical scope of its investigations and prosecutions and engaging in greater outreach to underrepresented regions would go a long way in dispelling accusations of double standards. Securing adequate funding remains crucial. The ICC's reliance on voluntary contributions from states parties makes it vulnerable to political whims and budgetary constraints. Exploring alternative funding mechanisms could provide greater financial stability and independence. In a world grappling with complex challenges, from armed conflicts and mass atrocities to climate change and global pandemics, the ICC's role as a guardian of international justice is more important than ever. The court's existence sends a powerful message that impunity will not be tolerated and that individuals who commit the gravest crimes will be held accountable. The ICC's deterrent effect, while difficult to quantify, should not be underestimated. The court's investigations and prosecutions serve as a stark reminder to those in positions of power that their actions have consequences. The ICC's commitment to due process and the rights of the accused is equally crucial. By upholding the highest standards of fairness and justice, the court reinforces the rule of law and strengthens the international legal order. The road ahead for the ICC will undoubtedly be fraught with challenges. Yet, the court's enduring significance lies in its unwavering pursuit of justice, its commitment to accountability, and its potential to contribute to a more just and peaceful world. The ICC, despite its imperfections, remains a beacon of hope for victims of atrocity crimes and a testament to the international community's commitment to ending impunity.